Hello, everybody. Hello, C-Rex. Hello, Nana Laura. Hello, Auntie M. Oh, I forgot to put my mic on. I'm going to have to get used to this. All right, give me just a second. Okay. We good? Hello, Sir Philip. Hello, Patrick B. Hello, Jenny Green. Hello, Finna7. Hello, Spider-Man. Thank you all for coming out tonight. Aw, you're so sweet. Thank you. Oh, what's up, sleepy little girl? What's up, sweet, sleepy little angel? Yeah, you want your treats? You want your treats? She was taking a little bit of a nap. I think we woke her up. She doesn't mind anymore. Oh, we've got a variety of fun tonight. Yeah, never co-sign on stuff. Never. It's a bad idea. Doesn't matter who it's for. Absolutely a terrible idea. Ha! All right. Give me just a moment here.
Good morning. Can I have your name, please?
Gary Thomas.
Okay, thank you. I will be with you in just a moment.
Gary Thomas.
Yep.
You know, you got a bench warrant out of the 34th District in Romulus?
Yep.
Okay.
They're not gonna come get me.
Okay. I just figured I would let you know in case you were unaware.
Yeah, they've been saying that for the last 4 years.
Okay, yeah. You don't have to say anything else. I just wanted to inform you.
Okay. Now calling case numbers 22S00157 and 24S00209. These are the state of Michigan versus Gary Rashad Thomas. Appearances for the record, please.
Assistant Public Defender Sonia Chanot on behalf of Mr. Thomas. Mr. Thomas, state your full name for the record.
Gary Thomas.
Thank you.
Thank you. So today is the date and time set for an arraignment in the matter ending in 209. The matter ending in 157 is just set for a show cause hearing. That means basically that you just owe money on that one. So with this case ending in 209 today, as I said, is the date and time set for an arraignment in this matter. What I have is a misdemeanor complaint that charges that on or about April 20th of 2024 at Road, you did knowingly or intentionally commit the following act or acts that under the circumstances posed an unreasonable risk of harm or physical injury to a child by leaving a child 10 and under in a public place while intoxicated and abandoning them to get on a city transit vehicle. This count is otherwise known as fourth-degree child abuse. Do you understand that charge?
I guess I do now.
Okay, and I'm sorry, I didn't catch quite what you said.
I said, I guess I understand now.
Okay, thank you. So that is a misdemeanor with a maximum penalty of up to 1 year in jail or probation for up to 5 years. Do you understand that potential penalty? I do
Yep.
need you to say it out loud. Thank you. Okay. Count 2 charges that at the same date, time, and location, again, you did knowingly or intentionally commit the following act or acts that under the circumstances posed an unreasonable risk of harm or physical injury to a child by leaving a child 10 and under in a public place while intoxicated and abandoning them to get on a city transit vehicle. So that is count 2. That is also fourth-degree child abuse. And again, that is a misdemeanor with a maximum penalty of up to 1 year in jail or probation for up to 5 years. So you understand that there are 2 counts against you.
So it's 2 counts of fourth-degree child abuse, the same shit? Excuse my language, I'm sorry.
Please be careful with the language you are in court. And yes, presumably 1 for each child.
Okay.
Okay. Okay. So did you have a chance to review an advice of rights form?
Yeah.
Okay. Do you have any questions about your rights?
Nope.
Okay. Attorney Chanel, do you wish to address the plea and the bond?
You said the plea and the bond?
Yes.
I'm prepared to address the bond.
Okay. Presumably he's standing mute to the charge.
Yes, Your Honor, we stand muted to the charges in regarding bond. My client is 33 years old. He is gainfully employed at Five Guys Restaurant. He is currently on probation and he is attending drug court in front of Judge Kunke. He also expressed that he is awaiting to attend an inpatient alcohol treatment program. I did explain the bond conditions to him. I do believe he will comply going forward. And my client did express that he will appear for subsequent court hearings. Therefore, we are asking for a personal bond. Thank you.
Okay. Attorney Chanel, do you know if the children reside with your client?
I do not. Do they live with you, Mr. Thomas?
No, they live with my girlfriend.
At this time, the court will set your pretrial for July 25th, 2024. That will be at 9 a.m. over Zoom before Judge Washington. And the court will set bond with the following conditions. You are not to use or possess alcohol, marijuana, or illegal drugs. You are to report to community corrections within 24 hours of your release for drug and alcohol testing. Prior to your release, you are to be fitted with a scram tether. You are not to have contact with the minor children at this point. When the court says no contact, the court means no in-person contact, no contact through the mail, no contact over the phone, via phone calls, text messages, emails, social media, the internet in any way, shape, or form, or through third parties. You are not to leave the state of Michigan without the court's permission. You are not to engage in any sort of criminal activity whatsoever. And you are to appear for any and all dates set for you by the court. So that includes your pretrial in this matter on July 25th at 9 a.m. over Zoom. It also includes going to community corrections within 24 hours of your release. You appear to have been muted. I did send a prompt asking the jail to unmute you. Thank you. Okay. And I should note that you are also not to go to the children's place of residence.
whatsoever. What is it? I took care of that.
Do you have any questions about any of these conditions?
Nope.
Okay. They will be entered into the law enforcement information network, so they'll be readily available to any police officers that you may come into contact with. And if they have probable cause to believe that you have violated one of these conditions, then they can arrest you on the spot, and you'll be held for a bond violation hearing in front of the judge, who may revoke your bond and set a new, more restrictive one. At this time, the court will set a personal recognizance bond in this matter. Attorney Chenault, do you have anything else?
Nothing further. Thank you.
Okay, thank you. And sir, if you don't have any questions for the court at this time, then you are free to stand up and tell the jail that you are finished.
And what a shocker. I went to the next date where he was supposed to have his hearing, and he was a no-show. So we're supposed to, you know, be okay with him because he's in drug court already, but he got intoxicated and left 2 kids under the age of 10 to get on a bus by themselves. I don't think his drug and alcohol rehab court is working for him. Hopefully that scram tether is doing what it's supposed to do.
Also have Crystal Ramirez here.
Okay. On the record in state of Michigan versus Crystal Ray Ramirez, 2400857SN.
Matt Nagel for the people. Jacob Riley on behalf of Ms. Ramirez.
And you're Crystal Ramirez? Yes. Thank you. Today's the date for final pretrial. What's our status?
I do have a victim present today, Your Honor. The victim also informed me that apparently Ms. Ramirez and the victim used the same nail tech. And according to the nail tech, Ms. Ramirez had passed a message through the nail tech to the victim, telling the victim not to appear today, but the victim did appear today.
Well, that would be an alleged violation of bond. If you would like, you could file a bond violation on that. But in the meantime, Mr. Raleigh, are you wanting to, I don't know if there's been plea negotiations today, or if you're wanting to just leave this on for jury in 2 weeks?
At this point, yes, we would leave it on for jury in 2 weeks.
Okay. And Ms. Ramirez?
Yeah.
Don't mess around with your bond. Bond is a matter of trust, right? So you get to be out in the community, and I trust that you're gonna follow the rules. So continue to follow the rules so that we can get through this trial. I'll see you back here June 24/8. I'm not asking for you to respond. I don't want to hear it. I don't want to hear excuses. I don't want to hear denials. I'm just giving you a warning right now so that you can continue to be on bond for 2 more weeks. No official bond violation has been filed. So this is just a warning, just to remember to mind your P's and Q's so that we can get to trial. Trial is June 24/8. Do you need a new trial notice, or you have yours?
You have notice of your court date, 2 weeks.
Sir,
We're okay.
Sir, no.
I don't-
No. No.
It's not appropriate. You won't be allowed to be in the courtroom if you can't sit and just be quiet and watch. So you can sit and be quiet and watch, or you can step out to the hallway. That's how this works. Okay. You said you have your court notice? Okay, remember to follow your bond conditions. I'll see you in 2 weeks. You're all set.
She started crying, and all of a sudden you hear, let me get my, and I think he said either girl or woman. And they're like, nope, shutting that down.
All right. Are you ready with Ms. Coles?
Yes, Your Honor.
Okay. On the record in state of Michigan versus Jessica Marie Coles, 2302313S. FY.
Matt Nagel for the people.
Thank you, Your Honor. Robert Palmer, Public Defender's Office, on behalf of Ms. Coles, who's standing to my left.
Are you Jessica Coles?
I am.
Yeah. Okay, so when we were previously together back in March, Ms. Coles entered a plea to an amended charge of use. Count 2 is dismissed. And we were originally going to have sentencing in May, but I think that was delayed because Ms. Coles had entered a treatment center. Looks like also 7411 was a consideration for purposes of this sentence. We have a pre-sentence report with some recommendations. Have council been able to go through that?
Yes, Your Honor.
Yes, Your Honor.
All right. Additions, deletions, corrections to the pre-sentence report.
Not from the people, Your Honor.
Your Honor, I do have a couple of minor ones. I do need to update her phone. I would prefer to do that off the record if possible. She was the victim in a recent domestic violence. It's been charged.
Write it down. David, will you just give Mr. Palmer some paper? Post-it note or something?
May I approach?
Yes, please. Okay. Okay, other corrections, additions, or deletion?
Yes, Your Honor, I do want to update the court with regards to the PSI. There's a section that talks about pending charges in Eaton County. I just want to give an update on that.
Yes.
The Ms. Coles has entered a plea. She pled to a possession of analogs and the methamphetamine charge was dismissed. So it's not, it says that she pled to a controlled substance methamphetamine. That's incorrect. The methamphetamine charge was dismissed as she pled to an analogs charge. She's also entered a plea. She's also been arraigned on, it says that there's a pending retail fraud first degree scheduled for arraignment on 6/6. She informs me that she has pled to that. They've now moved a sentencing date for both cases together. And she's going to be sentenced by Judge Hattie on July 20th.
Retirement or something?
What's that?
Isn't he retiring?
Well, I think he's filling in for Mauer at the time being though.
Oh, so he's filling in over in Eaton County.
Yes, that's my
That makes
understanding.
more sense.
Yeah.
Okay.
So I do have those, and then the rest of it, I guess, it's treatment related. I don't know whether the court, it's not really related to the PSI. I can just use it as part of my allocution.
I have a legal question for both of you.
Sure.
So it was an agreement that she'd be considered for 7411. At the time she entered her plea, she was eligible. However, now she's pled to possession of analogs. So I decided to look at 7411 and see what it says. It says when an individual has not been previously convicted of an offense under this article. Now she's been convicted. Is it an offense under this article? This possession of analogs, is it under the public health code? It's a 333 something. Does that make her no longer eligible for 7411?
That's an interesting question, Your Honor. Of course, having not done the research on that and being not prepared to answer that, I don't know the answer off the top of my head. My argument would be that at the time that she entered her plea in this matter, she was not yet convicted. And so there would still.
That's true, but when I have to impose the status, it's at sentence. And so,
Well, if it's at sentence, then I would say that she hasn't been sentenced in Eaton County, so her
no,
status.
but
hasn't
she's been
changed.
convicted. I'm saying I impose the status at sentence, but this says when an individual has not been previously convicted, doesn't say previously sentenced. So that's where I'm asking the question. Do we know, is there any case law on this or anything?
I don't know. I could certainly take a minute and try to find something, but I don't know off the top of my head.
Did she enter the plea here before she entered the plea?
Yes.
Well, she entered the plea here. Then she went out to Eaton County and pled out there in between her sentencing.
I think she'd still be eligible. Because at the time she entered her plea, she had not used it.
But she hadn't been sentenced and granted the status yet. And at the time I'm granting the status, I have to decide if she's previously been convicted. I'm gonna guess there's no case law on this.
I'm not going to object.
I know. There's a case about a simultaneous plea. Mr. Nagel, on behalf of the people,
We'll defer to the court. Thanks, Your Honor.
Mr. Palmer.
Your Honor, I was not prepared to answer this question when I came in this morning, so I don't know an answer. I would defer to
Go
the,
ahead with your allocation.
thank you. Your Honor, I would point out that Ms. Coles has been doing, since the court saw her last, Ms. Coles has been doing everything the court would expect and want from an individual. She is 52 days clean as of today. She's been dropping as part of her cases in Eaton County. Those have all been clean. She is currently working on employment. She's going through a CPS case in Eaton County. CPS is sort of at the moment encouraging her to focus on her sobriety and forego her employment, which I understand, but which is also makes life a little bit tough for Ms. Coles because of the income. With that set up, Your Honor, she has a number of programs in place. Some of these are on her own. She is set up to do IOP through Samaritas and Charlotte. She is dropping 3 times a week. Those have all been clean. She is attending NA meetings 3 times a week. Essentially, she attends sometimes 4 times a week. She essentially attends every other day. She has also set up, and this was ordered through her CPS case, she's also set up mental health counseling through CMH. So she's an active CMH consumer. And she is now also, as of recently, involved in New Hope, which is a program for victims of domestic violence. So she is certainly taking this seriously. She is trying her best to clear all of her outstanding matters. She understands that she hit a rough patch in her life. She acknowledges that. She's not trying to shy away from it. And she is taking responsibility for this. It appears that she's got a significant amount of programming set up in place for her to help her. She's got, as I said, the inpatient or intensive outpatient. She's got drug treatment, drug testing, CMH. I think all of these things are good things that are going to help Ms. Cole get back on track.
Good on her for all of the positive steps that she's been taking. And the sad part of this is that clearing up all of those, warrants of in other counties and trying to handle her business has actually now put this plea opportunity in jeopardy. They did spend a considerable amount of time trying to research case law on it to see if there was case law that could back up what they should do in this situation.
I would ask that the court grant her a term of probation of 74 months, if the court finds her otherwise.
Remind me when her sentencing is scheduled for.
Her sentencing in Eaton County on both files is now scheduled for July 20th.
July 20. Got it. Okay. Ms. Coles, what would you like to say?
I would really just like to say that I am regretful for my choices that my addiction caused. I'm also grateful that I'm in the situation that I'm in because if I wasn't, I'd still be using. And going to rehab was something I did on my own. And I'm glad I did. I have not felt better than I have in the last 6 years of using. It's the hardest thing I've ever done, but it's probably the best thing I've ever done. And like I said, I am regretful for my addiction causing me to make bad choices. But I am thankful because now I'm clean.
At this point, you finished your residential. Are you an intensive outpatient now?
Yes.
I have no idea whether, if this were to go to a higher court, whether they would allow me to grant the 7411, but at this point, I'm going to grant it. And because you're about to be sentenced in Eaton County and you have so many programs in place, you have to do a term of probation to earn the status. I'm going to place you on 2 months probation, which gets you past your sentence in Eaton County. And then I'm going to leave it up to them what happens next. So 2 months of probation under section 7411. Do not leave the state, do not commit crimes, meet with probation as directed, do not engage in assaultive or threatening behavior, do not use alcohol, marijuana, or controlled substances without a prescription, submit to random testing. The testing you're already doing should be sufficient. You just have to sign a release so that we get a copy of your tests when you do them, so that when you test, everybody knows that you're testing negative for substances. Do not attend any bars or nightclubs during probation unless you decide to get a job there. Then of course they could approve you to do that. Continue in your intensive outpatient treatment program, attend 12-step meetings as directed. Do not purchase or possess firearms, ammunition, or weapons of any kind. I will waive oversight fees, but I do have to assess the mandatory crime victim rights fee and state minimum cost. That's $125, which you may pay over the course of your probation. But don't make the money the reason that you're missing something. You can finish this up and still owe us money as long as you're making good faith efforts, but you need to focus on your treatment, just like they told you. You have 22 days of credit already on this file. If you would like to appeal my sentence and you need a public defender, you need to make your application within 14 days. Anything else?
Okay.
I think Mr. Warrensley has to take you down to probation and sign your probation paperwork. People give you an appointment to sign your orders.
Thank you.
You're welcome.
So she actually got to keep her 7411 status. That's awesome.
All right, could you please provide your name, ma'am?
Good morning,
Can you tell us your name?
Tasha Howard.
Okay. So, Ms. Howard, have you talked to your attorney yet?
I spoke with an attorney briefly on Monday, and she was not in my best interest, and she told me I had to get another attorney.
All right, well, I can't speak to any of that, but she's supposed to be here in court, so we're gonna just need you to hang tight. We need to rename you so we actually know who you are, because we've been trying to figure that out. You're not able to respond to any of the chat messages that we've sent, so we need to make sure that you're looking at your chat function and can respond. And we're gonna give your attorney a call right now and tell her she needs to sign in, so we'll put you back in the waiting room, okay?
Okay, thank you. I was trying to learn how to do it. My son was pulling up. This was my first time doing this. I was actually
Sure.
on my way to the courtroom.
Yep, you know, if you're ever concerned about participating via Zoom, we'd just rather have you here in person anyway, but it sounds like we have you now. We don't have video, but I could see you previously, so we're just gonna put you in the waiting room and try to get your attorney to check in as she's required to do.
Okay, my son just pulled up so I can get some help so I can chat with you.
Okay, no problem. So we'll see you in a few. We're gonna put you in the waiting room now.
Thank you.
All right, I just need Miss Vanek to come back, and I need Miss Howard to be unmuted. All right, so this is 24001897, the people of the state of Michigan versus Tasha Howard.
Do you hear Ms. Langley?
And for the record, Your Honor, Melissa Vinek, P53750, appearing on behalf of Tasha Howard. Ms. Howard, please state your full name for the record.
Yes, Tasha Howard.
Thank you. Your Honor, today is the day it's scheduled for a PCC. I had the opportunity to discuss this matter with Ms. Howard earlier on in this week, and just in general, to have a discussion with Ms. Howard. And from the very beginning, Your Honor, there is a client breakdown. I wasn't able to get any initial information. I wasn't able to really review anything. And at this time, Your Honor, since it's the very early stages of this, I believe that Ms. Howard may be better suited with another attorney requesting. I believe that there's a client breakdown.
Okay, so Ms. Howard, are you intending to retain your own attorney?
Yes, Miss, well, Your Honor, the reason that I said that I would like to have another attorney, she was not in my best interest from day one. So yes, there was a breakdown. She shut me down. So yes, I would like to have another public defender attorney that will be in my best interest.
Okay, so the two of you only communicated once, correct?
Correct. And she took me there. She was not in my best interest at all. I want to be somebody that's going to lift me up. I don't want to be brought down. She went like too far for the first communication. She was not in my best interest. And that's where the breakdown was at.
Okay, well, ultimately, whether or not another appointed attorney would be provided to you, that resides with the circuit court, because this is a felony case. So if Ms. Vanek is telling me that there is no ability to communicate with you because there's been a breakdown in communication, and you seem to be indicating the same, I can grant her motion to withdraw, but it's up to the circuit court if they're going to appoint someone else and who that will be. But ultimately, if you have a specific attorney that you're looking for, you may end up needing to seek someone out to represent you, because the public defender or the court-appointed attorney, they have to meet certain requirements as far as experience and knowledge to take the appointments. And then that's
Okay.
who's assigned to you. So I can let her withdraw. Both of you are basically telling me you don't want to communicate with each other. But it's
Okay.
up to the circuit court to determine whether or not another attorney is appointed. They decide who that
Okay.
person is, and then that will be the person that stays with you. You'll also have to come here in person next week for your preliminary exam, because I don't have an
Okay.
attorney here to represent you about a waiver. So you'll have to be here in person and hopefully communicate with a different attorney so you can be ready next week.
Okay, well, I will like to deal with another attorney, but I'm not waiving my preliminary. I want my hearing in district courts.
Yes, and
not
I'm not
waiving
asking,
it.
I'm not asking you to do that, ma'am, because essentially you have no representation right now. So
Okay,
you will
thank
be
you.
here next week for your preliminary exam in the afternoon at 1:30. If your
Okay.
attorney that's appointed needs additional time, they can show up with you and make that request, but we'll wait to see what happens next week, okay?
Okay, thank you.
Thank you,
All
Honor.
right. Have a nice day.
Thank you. Thank you, Ms. Howard.
Bye-bye.
Bye-bye.
Then the case that is oldest on our docket in which both parties are present, we're going to hear that one next. That's going to be 23-1310. Priya Nathan versus Anita Rosas. For parties that are here for cause 24-109 Greer versus Kendall, you're welcome to turn your cameras off while we're hearing this other case. If you need to step away from your camera, if you need to step away from your computer, your device to use the restroom or make a call or something like that, just please send a message to our clerk, Roche. You can do that directly in the chat for Zoom. You could put it in the generic chat for us, but just let us know where if you're leaving and don't be gone, too long, because that's essentially leaving the courthouse. All right. But I just want to give you that notice before we get started. All right. Now we are going to begin again with Priya Nathan versus Anita Rosas. On behalf of Priya Nathan.
Hi, Your Honor. I'm here.
Good afternoon. And on
Good
behalf of Anita Rosas.
I'm here.
All right. So we have both parties. Good afternoon to you both. All right. And Miss Nathan, are you suing the defendant for money or property or both?
For money, Your Honor.
And how much money is being sought?
I'm seeking $19,935,000.
$19,935. All right. And what is that from? Was that a loan? Is that damages?
Yes, I can explain quickly, Your Honor. So in 2021, September 2021, the tenants of this house, which is in South Austin, signed the lease. The tenants are the defendant's son and daughter-in-law. And at that time, Ms. Rosas agreed to be the guarantor because the son's job was volatile, and I had requested they have to have a guarantor. So she signed the guarantor. I sent all the evidence to the court, the lease, the guarantee form, the extension and everything, Your Honor. The guarantee form is signed by Ms. Rosas, and it's good for 6 years. So just wanted to give that for reference, Your Honor. And the lease was further extended till April 30th of 2023, I apologize. And then another month was extended for May of 2023. All of these extensions are sent to the court as evidence. The first thing is the tenants did not pay May rent in full. Second, they never paid the rent on time any given month. They would only pay half in the first and the half in the second. And I couldn't keep track of it in the end because there was so much late fees. Third is the biggest one, Your Honor. They caused so much damage to my property, Your Honor. It is so heartbreaking. And I'm, just like anybody else, I'm a working single mom, and I had to fix everything on my own to get the house back in a decent condition. I mean, they went from like big holes, gaping holes in the wall. Like if you take a hammer and bang the wall, like they left holes in the wall. The doors were damaged, Your Honor.
All right, Ms. Nathan, we're going to get that's going to be testimony. Okay. Help me break it down. I got rent, late fees, and damages. How much is the rent for May that you're seeking?
Would you give me 1 second, Your Honor? I have the document up. Can I pull it up, please?
Yep.
I just don't want to give you an incorrect number.
Oh, me either.
Yes, ma'am. So for the May unpaid rent, along with the late fees and unpaid rent.
Just the May rent, just the rent. What was the rent?
Well, there's also some undue late fees.
Miss Nathan, you told me it's going to be May rent, all the late fees and damages. So break it down for me that way. How much is just the rent that they would have paid in May if they paid it on time?
$625.
And then how much are all the late fees that are part of the judgment today that you're seeking?
They are $50 plus 15 for 30. Oh my God, I have to break this down. Give me 1 second. I would say the late fees alone is $325, Your Honor.
And then how much are the damages?
The damages are quite a substantial amount because I even sent the broken down letter to them and to the court. So 19,935 minus 625 would be all the property damages they cost that I had to fix.
And then minus out the late fees. If I take 19,935 minus 625 for the May rent and 325 in late fees, you're alleging $18,985 in damages.
That sounds right, Your Honor.
Okay. All right. Let me go ahead and swear in both parties. Then Ms. Nathan, Ms. Rosas, will you please raise your right hand for me? Do you understand that by appearing today and offering testimony, you're both swearing to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Yes. Okay, fantastic. All right, now, Ms. Nathan, you said in your opening here that Ms. Rosas was the guarantor on these matters. So she is not the person who actually lived in the property, nor is it alleged that she herself caused the damage or paid anything late, simply that she's the guarantor for this.
Yes, but yes, Your Honor, she is the guarantor. I mean, according to the Texas Realtors lease, which she takes responsibility. Sorry.
I got what a guarantor is, Ms. Nathan. I'm just asking yes or no. She didn't live in the property, correct?
Every time I went to the property, she was there, Your Honor. So
Is she listed on the lease as a tenant or an occupant, or was she just listed as a guarantor?
She's listed as the guarantor, not as a tenant.
All right. How about the actual tenants?
Yes, Your Honor. So these, so like I said, Mr. Taylor Rosas is Miss Anita Rosas' son, and his wife is her daughter-in-law. And I've tried to reach them many times. They left without, they practically abandoned the property. They didn't leave a forwarding address, which is per the lease. They have to leave a forwarding address. They did not leave that. And I tried to contact them through phone and they wouldn't respond. In fact, they were sending abusive messages. And that's when I reached out to Ms. Rosas to get the property damages reimbursed.
But you didn't include them in the lawsuit.
I didn't know how to contact them, Your Honor.
It's just a yes or no question, Ms. Nathan.
Yes, you're correct.
I understand there's nervousness here, but I'm just trying to understand why, if people lived in your home and they caused damage, they're not included in the lawsuit. Just a question. The answer is no, you're not including them in the lawsuit. You're just suing the guarantor.
Correct, Your Honor.
All right, that's fine. Now, the tenants leased the property in September of 2021.
Yes, Your Honor.
And there was a written lease for that?
Yes, Your Honor.
All right. And are you a realtor?
And at that time, no, I was not.
What type of lease was used?
A Texas as a residential lease.
And did you use a realtor to help you locate the tenants?
No, they were already, they were renting it as different parties, and Taylor was the only one taking on. So they were already from, if you have a minute, I can explain. So there were three other people along with Taylor Rosas, who's Anita's son, living in the house. And then the rest of them moved out. So I had to redo a lease because of parties.
Got it. When did Taylor first come to be in possession of the property? What year was that?
I would say 2016.
Got it. So 2016 is when one of the tenants actually began living in the property. And then parties to the lease changed. And in 2021, the lease you're pursuing came into effect.
Correct.
And that's when the defendant, Ms. Rosas, signed on as a guarantor, was in 2021.
That's correct. Yes, Your Honor.
When the lease in 2021 changed the parties, was a walkthrough done? Was there any new inventory? Were there any damages assessed to the old tenants when they left?
I did a walkthrough, yes, Your Honor. There was all these damages. The the hole in the wall, Taylor verbally accepted that it was he and his brother who did that.
Was
But
any money assessed to the people that moved out?
no, Your Honor.
Okay.
Well, they did some damages, which the old deposit was used for that.
Do you have that accounting?
Well, I might have it in email, but that original amount was really like $1,400, Your Honor, which there's so much damage that the cost, even at that time that I had to use it to repair the AC.
But it wasn't so bad that you weren't willing to let Taylor continue to stay there and sign a new lease.
No, the damages were not anywhere near what I found it at the end of this lease. Because yeah, you're right, Your Honor.
And in 2021, when the new lease was signed, was a new security deposit required?
No, I did not take that in good faith, Your Honor. I mean, Taylor was struggling. He didn't have a really good. I did a lot of things in good faith, Your Honor. So I didn't take the deposit, which is my mistake. And they were having a baby or something. So
so in 2021, the parties switched. You have a new tenant. You gave the old deposit from 2016 back to those people, and
correct.
the new lease has no deposit on it.
That's correct, Your Honor.
Okay. Instead, you had the defendant sign as a guarantor.
That's correct, Your Honor.
Okay. And in 2021, the lease amount was $625 a month?
No, Your Honor, that was just the balance of the rent. The lease amount was, I can tell you, Your Honor. It was $1,800, Your Honor, at that time.
Okay, so it's $1,800 in 2021. And then the tenants lived there until May of 2023?
Yes, the lease was extended till May 2023, but they left, like, they just abandoned and left by mid-May, I think. I don't really know when they left exactly.
So
because
sometime in May of 2023, you got back possession of your home from the tenants?
Yes, Your Honor.
Got it. Okay, tenants left in May 2023. And did they provide a forwarding address when they left?
No, Your Honor.
Okay. Did you create an itemization of the damages that you discovered when they moved out? So in June of 2023?
Yes, Your Honor, I did. I sent that email to the tenants and to the guarantor, and I also sent a copy of that to the court, itemized, like, may I just add that I also found out so much damages before they moved out, and I specifically asked them to repair it, and they neglected it.
That's fine.
So, yeah.
They've left. You have your property back. You go over, you inspect it, you discover damages. Did you send an email or a letter of some type with an itemization that says right now at the end of June or July, here's the damages that I've discovered?
I did, Your Honor.
Okay.
7 times.
And
she needs to just take it down a notch. She wants to get all of her information out all at once, but there's a process. You just gotta be patient.
when's the first time you sent them a notice? In June or anytime after they left in May? What's the first time you in writing said to the tenants, here is the damage that you caused and the money I'm seeking?
I sent it May 30th because they left it at some point in May, and I was able to go and assess the damages, Your Honor. And I
Okay.
sent that first one end of May.
All right. And was that an email? How did you send that to them?
That was an email, Your Honor.
Email. All right. And in May 30th, when you sent them an email, at that point, how much in damages had you discovered?
Well, I had gotten some quotes from people. I would say it was around, I estimated
Do you
around.
have the email? Because that's
Yeah,
the best evidence. Take a look at the email.
Well, I did not put a dollar amount on the email, but I stated out all the damages very clearly as to what was done. But
Okay, all right.
on July 1st, Your Honor, I personally went and dropped off a printed letter to the guarantor's house, and I have a photo of that as well, and said that this is the
Miss Nathan.
Sorry.
We're going to get through everything that happened, but I've got to follow a systemic path. I want to know exactly what happened because the rules around this are very specific, right?
Yes.
And I understand you're emotional. I see that. Take a moment. You're good.
Sorry,
They
Your
moved
Honor.
out in May. You went in, you found your house had damage to it. You sent an email. The email didn't have any money in it. It just said, here's damages I discovered.
The first email, Your Honor.
Yeah, that's what I'm talking about. The first one.
Yes.
What are the things in the first? Did you send us that first email by any chance?
I did several, yes. Briche, could you see if I sent that email evidence?
Miss Nathan, we'll look for it. I'm just asking you if you know for a fact. Did you send
Yes.
the May email?
I did, Your Honor.
Okay. And do you just right now, off the top of your head, recall any of the damages that you mentioned being in that May email to them? What was noted? What did you notify them of first?
Pretty much all of the damages, Your Honor.
Well, I need you to be specific, Ms.
Okay,
Nathan,
yes,
right?
yes, Your
So
Honor.
what was in the May email? What did you say? Because then you, in July, it sounds like you went and got actual cost to fix those things.
Yes, Your Honor.
What
So,
did you highlight in May? What were the damages that were said? Because I've got lots of exhibits from you, but they're not beautifully emailed, right? I've got an email of a non-renewal. I've got a final walkthrough. I've got a move out process. So in May, I see one about May rent being overdue, revised demand letter with damages.
yes, Your Honor,
If you get to it faster, that'll be helpful. What did y'all say in May? Here's things that we discovered.
Yes, so I said the discovery included severe damages to the air conditioner and air duct because
air conditioner. All right, that's one. What's the next one?
Damages to the wall because there had several holes in it.
Do you specify what walls, or does it
Yes.
just damages to the walls?
No, I specified specifically the bedroom wall had a big hole.
Bedroom wall. And what was wrong with the bedroom wall?
So the master bedroom wall had a huge hole in it, Your Honor, like a really massive hole where it was like you have to like do construction work to fix it.
Okay.
And I pointed at that. I actually said that to them many times, even before they moved out. So that was in my email. Can I go to the next one, Your Honor?
Yeah.
The back door was severely damaged. The door to the backyard was severely damaged. It had to be replaced. The bedroom.
What was damaged about the back door?
Well, the whole door was ripped. I mean, it like you know, if you had like if somebody ran over it, like they were like missing. There was the bottom of the door was completely torn apart. Like it's hard to explain. It was just it was like weather damage, and I don't want to say weather damage really, but it was something like somebody rode on it, like it was like, you know, yeah, it had a big hole in the bottom, Your Honor, so it had to be replaced. So that one. Okay. And there was no way that house was secure without the door being replaced.
Okay, back door. What else?
The bedroom door, the master bedroom door was sort of like if you take a knife and just like cut off the top. So it was a weird, I don't know what they did. Maybe they got into a fight or something. So anyway, that door had a lot of damages that had to be replaced as well.
Okay.
And then the floor was just, they had pets. They didn't tell me about the pets. So the floor was completely ripped off. Like it had like patches of dirt and holes, and
it was floor throughout the house or in one particular room?
Of the whole house, Your Honor.
What type of flooring did you have in the home?
So the first floor had like tile, and the tile was broken in so many places. And then the second floor had carpet.
Okay, so broken tile on the first floor, dirty carpet on the second floor. What
and
else?
The floorboards were all messed up, you know, and it's like they took a vehicle and drove on it. Everything had to be replaced, Your Honor. The next thing was the refrigerator. I had a brand new refrigerator in there when they moved in. That was completely taken apart. It was like a garbage can sitting in the garage. It was just, yeah, the whole refrigerator was dumped.
Just so I'm clear, the refrigerator that you had put into the kitchen for them to use, when you came in May, that refrigerator was in the garage?
Yes, Your Honor.
What was where the refrigerator should be? Was there another one there?
Apparently they bought a new one for themselves, and they took that with them, and then they dumped this one in the garage.
Was the refrigerator still working when you moved it back and plugged it in?
No, Your Honor, it was completely damaged.
Okay, what else?
And then the garage, I think they had a dead animal in the garage for months. And so the garage was sort of very unsanitary, like a health hazard. So I had to completely like redo the garage with sanitization kits and new paint. So that was that, Your Honor. And then they also damaged most of the appliances in the kitchen were not working, Your Honor. And they also took the washer dryer with them, which I filed a police complaint, and I
Okay.
have a record of that.
Kitchen appliances weren't working. What are the appliances that were in the kitchen?
So there was a kitchen range, an oven, a microwave.
Is it a cooktop and an oven, or is it one big stove unit?
One big, Your Honor, like a range.
Stove. So the stove wasn't working. What else?
And the microwave, there was no microwave, I apologize. But the range and the cooktop were not working. They were all like dismantled or whatnot. So I had to get new ones. The washer dryer, I had put that in and they took that with them. And I asked, I filed a complaint about that.
Okay. All right. Anything else?
And yes, Your Honor, I'm just making sure I cover the list. They also did not do any yard work, which is contractually they're supposed to maintain the backyard and the front yard. So it was, I had to fix that. So that was also on the list. They did not take the trash out. Like they left all the trash in the house, like a used mattress and a trash can overflowing with food and old food. And so I had to call the city and get that cleaned out. They had also terminated water and electricity without telling me. So I had to pay the city to get that reopened. So yes.
Ms. Nason, does the lease require that the utilities remain connected for a period of time?
Yes, Your Honor. They're supposed to notify me of the landlord of a move out day and time, and they're not supposed to disconnect electricity.
Okay, what else?
One moment, Your Honor. I'm just checking one last time.
Yeah, I see that a lot of the exhibits you sent us, I can't see. There's a big icon on them instead. So like we got a 60-page document here. And this is June 2nd, 2023, but that's about right. That's the following month, right? They moved out May, and then here's an email from you to the defendant and then to two other people, a Taylor and a Camille, and it's dated June 2nd. And then I think the photos that are attached, we're not seeing in the attachment that you sent me, but you did take photos?
Yes, Your Honor. Yes.
Do you have those on your computer there?
Yes, Your Honor.
Are you able to pull those photos up and view them on your computer?
Yes, Your Honor. But it's a separate computer. But
that's what I'm saying. If they're they're not on the computer you're using right now.
Yes, Your Honor.
Yes, they are on the computer you're using, or no, they are not on the computer you're using.
They are on a separate computer. I'm on a different computer, Your Honor.
Any way you could send those photos again, because I'll share my screen with you and you'll see what I mean. Photos are going to illustrate the extent of damage far better than descriptions from words, because people say big, and then I see things like this and I see things like this, and what's relative is relative. But here's what we did receive. So a 60-page exhibit, and this is a letter that began June 2nd, and it says, and then it details damage to it, but then the photos that are supposed to be included all look like this.
Well, this is a different one. This is all the invoices, Your Honor. The photos
I'm just saying that in order for me to see them, they didn't come through with what you sent us. So I would like to be able to view the photos. Do you know if you sent them to us again?
I did send it. I don't know if I sent it 2 times. I did send it once, but I can send it again, Your Honor. That's no problem.
That'd be helpful. I'd like to see photos.
Yes, Your Honor.
Well, let's see. Hold on. Here's 42 pages. Let's see if these come through. Okay. All right. So let's see. So they moved out sometime middle of May. They didn't give you an address. You went in, you find there's a lot of damage. You send them an email that says, hey, there's a lot of damage. Here's a list of things. And then after you sent them that email, did you then go ahead and affect any repairs or get quotes to make any repairs?
Yes, Your Honor, I
Okay,
did.
and then after you did those repairs and you got the quotes, did you send them another letter that said, here's what it's costing, here's the money that we're seeking?
Yes, Your Honor.
When
Yes.
was that letter?
That was sent in sometime in June 17th. I sent them that letter. All along, I mean, I had to also fix the repairs because that's my, I have to get income from it. So yes, I did send that. And then at the end of it, I also sent one after completion.
And what was that email? What date is the final one that says, here's everything it cost, please pay?
July 1st.
And was that one submitted to the court?
Yes, Your Honor.
Okay. Let's see if I can find that one real quick. Rashay, if you find it too, we got a lot of exhibits in here.
What is it titled?
It's titled, it should be titled demand letter, Ditmar demand letter, or final demand letter, or.
I have one that says demand letter, but that's the one that's dated June 2nd. And then I have another one that's dated demand letter, and that's dated June 1st. And then it says updated letter filed with JP3 July 13th. So it's not clear to me that this is actually a copy of the letter, but that one has a total amount at the end of $19,935. So this is the one I think you created to show me in court, but not one that you actually sent.
No, I sent
before
that
the
also.
lawsuit.
I sent that one also to them, Your Honor.
Yeah, but I'm wanting to know what you sent them before you had to sue them. Right? So they moved out in May of last year. You went in June, you emailed them. I got that email, right? In June, you're saying, here's all the things you caused me damage of. And then you got it repaired. And then did you send them a demand that says, here's what you owe me?
Yes, Your Honor.
Before you sued them?
Yes, Your Honor.
And that's the one I'm trying to locate.
That was on July 1st, Your Honor. And not sure I can resend that.
Please do. That may be faster than us going through lots and lots of things trying to find it. But I'm
that's
what
easier.
the total amount is.
That's
what was
easier.
the letter he said, all right, here's everything that cost me. Please pay. This is the amount that you owe.
Yes, Your Honor. I have it open actually, and sending it right now.
Thank you. I see that same one from June, and then I see here's a revised one, but there's like an attachment to it. Okay, in the meantime, then I'll give you a minute to send that, and then I want to ask you to identify these photos that you sent me. And if you're looking at that email, the final one that you sent them, what was the amount of money that you asked them to pay for damages?
The same one I asked, the 19,935, Your Honor.
Okay.
Because by that I had to get the repairs done.
Okay. Let me share my screen with you then. Okay. Here are photos that were submitted, and we'll go through them. I'm not probably going to go through. We may go a little quicker because there's 42 items, but let me just ask, Ms. Nathan, do you recognize this photo?
Yes, Your Honor.
And who took the photos that are here and included in all of these photos? Who took these? Did you take them? Did someone else?
I did, Your Honor.
You took the photos. And when did you take these photos?
When I went there and they were moved out, and I found out that there was nobody there. So I would say I think May 15th or 16th is when I went there first.
So sometime around the middle of May in 2023, shortly after they left.
Yes, Your Honor.
Okay. And when I'm looking at this photo here, on the left-hand side, the white wall, is that your house or the neighbor's home?
That's my house, Your Honor.
Okay. And is this to the side here, the yellow one-story with the green, is this the neighbor's house?
Yes, Your Honor.
Okay. And what is this in the center here?
They left that like that. I think it's shrubs from, I don't really know how it got there, but I had to clean it up.
Okay. And what is this a picture of? Is this, I mean, I know it's a picture of an air vent, but is this first story, second floor?
This is the second floor, Your Honor, that the dirty air vent.
Is that the same air vent or a different one?
This one's a different one, Your Honor. This
Okay.
this one is on the first floor.
Okay.
This is the dirty the air vent. above the range.
Okay, that's the hood. What is that a picture of?
This is the damage to the garage door. It's I think the picture is cut short, but this is the picture of the garage showing
So
the
this
damage.
is a picture in the garage of the door into the home?
Correct. Yes, Your Honor.
Okay. Yeah, you see the side stripping is missing. Is
So
that
this
an
is
air vent?
air vent. Yeah, it was just open like that.
So it's missing the grate?
Yes, Your Honor. This is the way they left the bathrooms. I didn't include that on your list, but the bathrooms all had to be replaced, Your Honor.
What is this?
This is the hole in the wall.
I mean, I definitely see it's a hole in the wall. Any sense of, you know, that's hard for me to get scale when I look at that, right? Like there's no measurement, there's no hand by it. I don't know how big that is. I definitely see there's a hole in the wall.
Yeah. Yeah, it's I did my best, Your Honor. I mean, the pictures.
I understand. I'm just, you know, when I look at it, I see there's a hole. Right. And it's bigger than a pinhole, right? I mean,
Yeah.
there's stuff here. Okay. But it's not, I mean, okay. All right. How about this? Carpet's coming up as you go
Carpet's
into the
coming
other.
up. Yes, Your Honor.
What room is this with the wood flooring?
This is the one going from the wood flooring is the laundry room, and it's going into the laundry room. Or yeah.
Okay, and what room is the
This is
carpet?
it's like the walkway of the second floor. There's a small walkway on the second floor.
And the laundry's upstairs?
Yes, Your Honor.
Okay. How about that?
This is just a picture of the floor, how they left it, the house itself.
Okay.
Again, this is a picture of the floorboards. I couldn't take a picture of this toilet, what was inside.
What bathroom is this?
This is the ground floor, has a powder bath, like a room. And this is how they left it, Your Honor.
Okay. What is that?
These, the thing they're not showing, like these are damage to the walls. Just it's hard to focus in, but just several dirt spots.
Mm.
This is the bathtub. It's not doing justice, but it was just nasty. I had to take this off. And
Is this a guest bathroom, a master bathroom?
this
What
is
bathroom?
the master bathroom.
All right.
This is the bedroom door I mentioned, Your Honor. Like, you see how it's scraped off?
Oh, so like the side molding on the door has been pulled off?
Yeah.
Okay, it's missing pieces. Is that the backyard?
Yeah.
So the neighbors put up a fence but didn't split it with y'all?
They didn't.
Well, that's like good neighbors and good fences, right?
Yeah.
All right, so this is the backyard, so not mowed, not maintained, just stuff growing in the backyard.
Yes, Your Honor.
Okay, now this is the back door?
Yes, Your Honor.
Oh, I see what you mean. There's a big hole right here. See, now this I
Yeah.
can get scale of, like I can look at that size of the tile. This is probably 12-inch tile. That's a foot of missing of the drywall and the molding is gone. The door is damaged at the bottom. I see that. Okay. Same thing. Picture in the garage.
Yes, Your Honor. This is
With
the
all of
garage.
this stuff,
They left it, Your Honor.
these were their items?
Yeah. They just left. I had to clear all this out.
That broom was perfectly usable. They were doing you a favor leaving it there.
Okay.
And that's where the refrigerator was.
Oh, I see. Here's the hookup for the fridge. And so here's this is tile.
Yeah.
Okay. Yeah, I see stains.
This is the front yard, Your Honor.
Okay. Zoom back out so we don't keep doing that. What is that? Is that
This
the
is
front door?
the front door, also with some damages.
Huh. I mean, I definitely see damage. I'm trying to ascertain like what's happening here. But
Yeah, I was as surprised as you are.
what's that back door again?
This is the floorboards.
Oh, I see. Pretty dirty. I see. Is this like where the furniture sat?
Yes, Your Honor.
Okay. Different bathroom. Yeah. Laundry room upstairs. And so you leased it with a washer and dryer in it?
Yes.
And they were missing when you came back?
Yes, Your Honor.
Okay. Yeah, I see stains on the wall. Oh, and this is the fridge then that you found in the garage?
Yes, Your Honor.
Okay. What is this a picture? I can tell that it's under a sink, but what, I mean,
These are just like how they left it, like just dirty. The part of the contract is they have to clean the house and give it in the condition I gave, and that did not happen. So these are just pictures to show that this is how they left the trash. Like I had to clear all this out, Your Honor. And this is, yeah, another picture of the fridge. Look at it was in the garage. It was just dumped in the garage.
is this how you found it with the
Yes.
bucket and the toilet?
Yes, Your Honor.
What's the toilet from?
I don't know.
Okay.
I had to clear it out eventually. These are the broken blinds that I had to replace.
Okay.
This is all trash they left in the garage.
What is this? What is this a picture of, Miss Nathan? I mean, I see that there's molding missing here. Is this a cabinet? Is this a door?
Oh,
I'm not
yes,
sure.
Your Honor. This is in the guest bathroom in the second floor. This is just to show how, I mean, it was kind of coming apart, just to show the sort of like the mold and bacteria gathering there.
Okay.
And this is the way they left the sinks. Look at that. I wanted you to see that hole, Your Honor, in the sink. Like
Right
the,
here?
yeah. So I had to replace the sink itself. And these are just the blinds.
Oh, I see. Okay. And were the burners missing from the stove?
Yes.
All right. Rashay, did we get that letter from Miss Nathan that she sent us?
Oh, I'm just sending it. I was so focused on the photos.
Oh,
I'm sending
actually,
it.
go ahead and send it through. That's fine.
Okay.
In the meantime, let me take a look at the itemization that you had sent in. And then you said you had several of these things repaired and you sent us through many of those receipts. So let me just take a look here. I see an invoice for oven parts, a quote, itemized bill, a receipt. Let me open these up. Invoice from the door service, itemized bill, locksmith, envelope, payment. Our computer software, when you open too many exhibits, it's like, hey, it's going to be unstable. Got it. Okay. So I'm going to share my screen now with some of the invoices that you submitted, Ms. Nathan. I'd like you to just identify these for me.
Yes, Your Honor.
This one is HVAC and mechanical. I see that this is a bill for $11.87. What is this from?
This is for all the appliance repair, Your Honor.
Okay, so this is for the oven. I see that it's dated June 20th of 2023. And this is for repair work that you had done to the property?
Yes, Your Honor. So the oven was missing a handle, and then to replace all of the range tops and to clear out the duct.
Here's another one. This is from Louis Flooring. This is to you. I see that address there. This one's for $89.50.
This is for the floors Your Honor, all of the floors that had to be replaced for the first and the second floor.
Well, let's see here. Let's see, vinyl plank. I don't know that I saw anything wrong with the vinyl plank, but I can see, did we see any? I saw issues with the floorboards, wall damage. So this includes several things. So there's 900 for floorboards. There's 750 for the wall damage. 925 for blind repairs.
Yes, Your Honor.
575 for the bathroom repairs. House painting of 1,800. Deep cleaning, garage paint, dead animal clean out, 1,250. Junk removal, 300. And they got all this done by June 10th. Okay. And then here's another one. This is that letter, so we'll wait and see the one that you finally sent that
I'm
came.
sending right now, Your Honor.
It's fine. And then this is you making payments for things. That's fine. That's to the same flooring company. What is this a picture of?
Oh, I went to drop off the letter because the guarantee, the Miss Rosas never gave her true address. I had to find it out. And so I had to go drop it off before I give it to the court.
All right, now then, here I see this is the air duct cleaning, $4,600.
Yes, Your Honor. So this is all of the AC repair because they had never changed filters or cleaned which is the responsibility of the tenant. So I had to do all of the work to get the AC running again.
Okay. This is that same one. This is for Tucson door services, back door and trim, $675. Exterior pH door. What's that?
So that is the one is the back door, the one is the bedroom door that you saw, Your Honor, and the one is the front door that had to be still repaired. That was also in one of the pictures.
Front door. Master room slab door. So what kind of doors did you get? Were these not pre-done doors at Home Depot?
Well, they had to measure it, Your Honor, and fit it to that because I think they tried a couple of doors and it didn't fit.
I mean, this is a prefab house. These doors are all standard. You go anywhere and buy one and they fit right in. So what was custom about the door?
No, it's not custom, Your Honor. I just had to get a door guy to do it because I couldn't do it myself. And he came and did all of this, Your Honor. Like even to bring the door, I didn't have a vehicle for it. I'm just going to send a document now. Sorry. I'm going to send it from a different computer. So.
They charged you $45 for door hinges.
I mean, I negotiated as much because I was paying out of pocket, but
yeah, I know, but like, I mean, I don't know. It just sounds okay.
I'm sending the.
And then this is LED batteries, weed clear. Are these some? What is this?
I'm trying to remember, Your Honor.
LG cubic 20-foot. Is this when you bought a new fridge?
Yes, Your Honor. Yes.
Okay. So $857. So you bought a new fridge for $699. It was $50 to get it delivered. Well, they picked up the old one and took it away. So that's what the $50 is. And then including in that, you also bought some weed clear, some lights, 3-count basic something or other. So that altogether for the new fridge, weed stop and delivery was going to be $857.
Yes, Your Honor.
Okay. All right. And then You also showed us, one of the things you sent in was a notice that they were behind on the rent at one point.
Yes, Your Honor.
Okay, let me go to that one. So. Let's see, this was titled Email to Defendant letting them know May rent was overdue. So this is stated Saturday, May 6th. Official notice that rent is overdue as of today. According to the agreement and non-renewal served April 30th, you're responsible for May rent. Note that doing repairs does not relieve you of your rent payment. You'll be given a walkthrough on the last day. Okay, but it doesn't say how much rent was behind. And then there were move out process instructions given to the defendants.
Well, they hadn't paid any rent, Your Honor.
Okay. So here's March 11th. Please read this in full. Pre-agreed repairs. Back door needs to be replaced. Edges have to be fixed so it looks even and like new. Backyard fence needs to be fixed. This has been a discussion, so the fence hadn't gotten done. Both of the above need to be done by March 25th. Do a thorough check of the fixtures, broken items, chipped areas, wall holes, doors, cabinets, handyman. Use a handyman. Except for normal wear and tear, tenants must return the house to the condition given to them. This is true. Repairs after you leave have to claim from all three of you. This is just the process. I will list it for rent. Your co-op is needed. Keep it easy. Licensed agent will come through. Lockbox will be there. No one will touch any of your belongings. Yeah, all of that is fine. Okay, so you did say, hey, there's problems with the back door and the backyard fence. Please get these things fixed. That's in March. Okay. And then notice of a final walkthrough, but no final walkthrough actually happened. Is that what I'm understanding? They left beforehand?
Yeah, I didn't even know when they didn't tell me, Your Honor.
Plan to do a walkthrough May 28th or 9th to assess the condition. Note that electric and water need to be on till then. Appliances don't turn on because of no utilities. That's considered non-functional. All right. And then original copy of the lease. Here it is. And then the lease extension, but here's the original one. Yes, thank you. Software, I understand. Okay, so TAR lease between plaintiff, these two parties. Ditmar Oaks, primary term was going to be October of 2021 through September of 2022, but then it got extended. Okay. Parties had 30 days to give notice if they didn't want to renew. Monthly rent was $1,800.
And there's an extension also, Your Honor, for this.
I'll take a look. I'm just.
Yeah.
Extension is just that one page extension. So I'm looking at what the original lease was on things. So originally it was $1,800. Prorated rent didn't have any. Place of payment, method of payment. Late charges, $50 per day and then 15 thereafter. Return payments, $100. Pets, no pets.
So one point of clarification here, the property that they're living in, they had been living in since 2015. She didn't own it back then. The son of the defendant was living there with some friends of his. All of his friends ended up moving out. He remained. So when she bought the property, he was already there. That's what they had stated in the beginning. So she did install the new fridge and stove and everything else she had said. But basically he just, assumed the lease on his own with his mom as the co-signer when she bought the property.
No security deposit. And all the things that can be deducted if there had been a deposit. Utilities. At all times as leases in effect, gas, electric, water, wastewater, and garbage services. And then occupants under the lease, people who could be there but weren't financially responsible, guests. Well, parking rules, trip charges, key box. Ability to show the property, leased as is, inventory form. Was an inventory form provided?
I did.
you get one out?
I never got one back, Your Honor.
Okay. Keep it clean and sanitary, dispose of all garbage, supply and change the heating and AC filters once a month, supply and replace all the light bulbs, maintain levels of chemicals and matters of any water softener. Eliminate any dangerous conditions, necessary precaution to prevent broken pipes, replace any lost keys, periodic extermination costs, remove standing water, know how to turn off the water cutoff. Yeah, that's a big one. Water the foundation, notify the landlord in writing of all repairs. Yard, maintain the yard, not limited to mowing, fertilizing, trimming, controlling pests and weeds, removing debris. Tenant will maintain the yard. No pool or spa. Tenant should not remove any part of the property or personal property that was the landlord's. Don't remove, change, or add keys. Don't make holes in the woodwork, except for the small nail holes to hang a picture. Don't permit any water beds, phone video cables. Don't remove any flooring, paint, or wallpaper. Okay. All standard stuff here. Payment of repairs. Here's the section though about what happens. Payment of repairs. Security devices, smoke alarms, liability holdover. Special provisions. No special provisions added to this one. What happens if someone defaults? Early termination. Okay, addenda. We're gonna have lease guarantee, insurance addendum, maintenance addendum. Did the tenants maintain renter's insurance on the property?
They are supposed to, Your Honor. I don't know that they did that.
All right. And then there was a renewal. Here is the lease guarantee as well. Actually, I'm going to stop staring at my screen just for a second. I don't think there's any privileged information, but I want to make sure I'm not trying to flash Ms. Rosa's personal contact information or anything about her. But I do see Anita Rosas docu-signed it, and that is for the guarantee for a lease by a Taylor and an Ashley at 8710 Ditmar Oaks. And then, yeah, this is the page I didn't want to share because this has, you know, more private information, and we're you know, live in the world, not trying to share that, but I do see a guarantee. Okay. And then the extension that came to extend the lease.
Your Honor, on the date of, I'm sorry. On the extension, I did not sign an extension. I did not participate in the renewal. My guarantor signature was only till that the primary lease. So the residential extension, residential lease has a second page here that I signed in 2021. That's not part of the 2022 signatures.
Ms. Rosas, on the original guarantee, section C says that this guarantee applies to all renewals as well.
Okay, I wasn't aware. Thank you so much.
But it does, it's included. It's section C on page 1. This
Okay,
guarantee
all
applies
right.
when the lease commences and continues until it ends, including any extension or renewal. The
Okay,
last date
I
at which the renewal will renew you is September 30th of 2026.
Okay, already. I was not aware of that. Thank you for clarifying that.
Okay, and then I see the extension, which was signed, moved the rent up then to $2,000. Okay. All right, and then Brashay, did we get that?
We did, Your Honor. It's attached on the documents.
Fantastic. Let me go through and just pull that one up real quick. If y'all forgive me for just a minute here, I'm gonna have to close all of these windows and let it reopen because it wants to keep being difficult. Well, Okay, that's pretty much the one I'm looking for. It's just June 1st and not July.
Yeah.
And this one is for 13. I'll just share my screen now. So this is a demand letter that plaintiff sent to the defendant tenants. And then defendant, Ms. Rosas, you're included in this one, or at least it's titled to you as well. So demand letter. The sentencing co-signers, you're responsible to return the house in condition minus reasonable wear and tear. You've not done enough to care for the home and its condition. Detailed damages below your responsibility. Unpaid rent. April was $50. May was $1,200 for a total of $1,250. So Ms. Nathan, you said that they owed $625. Did they pay some portion of the rent, or was it actually $1,250?
No, that was just I think I was breaking it down by late fees, Your Honor. I apologize for the confusion. I was trying to split it for you for like rent. So the May rent is unpaid rent is $1,200, Your Honor. That they did not pay that. And then the April was, you told me not to bring April up, but I'll just stay with May. And then the May rent was not paid. And the late fee that I calculated was $50 plus $225 for 30 days is $450. I really apologize for
that's fine
for mixing up the numbers.
Yeah, that's fine. They didn't pay all of May's rent. So the rent was $2,000. Did they pay $800 towards it?
Yeah.
Okay. And then the bigger portion of everything though is the property damage. And then you put in the HVAC stuff, damage to the walls, damage to the floors, damage to the baseboards. Damage to the doors, appliances. And I see, so you don't actually assess them the $1,950 for the door, the flooring planks. Instead you say, it's what I would have given you here. The baseboards, the broken tiles, the $900 patching, damage to the walls. Okay. Doors, $1,545, fridge.
Yeah, the revised letter, you had asked me for the first version, right? And then I sent a revised version to them after I fixed the air conditioner. And that had the $19,935, Your Honor.
Okay.
So the final one I sent, I went to Miss Rosa's house and dropped off, had all of the, after the fact that I did that work.
All right. All right, Ms. Rosas, I'd like to hear from you now. So Ms. Nathan has shown me quite a few photos. She's shown me the information where she sent it to. And just so I'm clear, you're related to one of the tenants, is that correct?
Yes, I am the mother of Taylor Rosas.
Okay.
The property has been leased for since 2015 by multiple people, multiple tenants coming in and out. Taylor was the last standing tenant. I, at no time, have ever lived at the home or resided or spent the night there. I just want to clarify that. My husband and I had our own private apartment, and where the plaintiff is aware of. So
no, actually, you're just here as a guarantor. No one is saying that
right.
you caused
Okay.
damage. I get that. You signed on to help out your child, and per the evidence I'm seeing, your child left the home with quite a bit of damage. So do you have any information or testimony that, are they going to be here to try to counteract what I just saw? Because it sucks that you're stuck with the bill for what you didn't do. That's the sadness with a guarantor. So do you have, are they going to come and testify that none of what I just saw is accurate?
No, I didn't know I could bring them. I didn't know I could take the text message.
Bring any and all witnesses that you want. Do you have any evidence from them historically that says they didn't cause the damage I just saw?
I know they have evidence on their phones and emails to counter the washer and dryer, the request for the water damage on the door for repair. I know there's those emails. I do not have access to those. I didn't.
Ms. Rosas, unfortunately, today is the day for court. You absolutely could have either told them, hey, I'm getting stuck with a bill for stuff and that I was nice to y'all at, come to court with me today. You can right now, I'll give you 10 minutes. You can call them and get them on the phone and send them the Zoom link and they can appear right now and you can present that evidence. But otherwise, she's absolutely meeting her burden more likely than not. Would you like,
Okay.
I can give you that time and you can get them in here if you think they can give evidence to help try to bring down some of this number. But what I just saw is significant and would definitely go beyond normal wear and tear, even for the length of the lease that existed there. I've lived in my home for 15 years. I've never damaged my door like that.
Yeah, I understand that. My son does not have a phone for me to be able to call him. I can reach out to Ashley and see if she's able to email over the documentation showing that she bought the washer and dryer. She can, I believe
washer
there's
and dryer
also
aren't included in the estimate that I'm looking at here. So here's what I've got.
Oh, I'm
right?
sorry.
Here's what I've got. She just showed me receipts and photos to back up that things need to repair. The oven, the floorboards, the wall, the bathroom being dirty and needing repairs, the garage needing to be cleaned, junk removed from the side of the yard and from inside the home, the air ducts, that's the big one. And the photo she showed me of the state of that air vent, I agree. I mean, she's more likely than not, I can see that that is true. Back door, definitely damaged. Front door, it had damage. Master bedroom door, it had damaged. Door fittings, okay. New fridge and weed stop. I saw the fridge in the garage. That's $11,824. On top of that, she has historical evidence that rent wasn't paid. Right.
yes,
What I haven't had, Miss Nathan, is other evidence to get to the 19,000. But right now, the number I'm at is looking at about 13 grand.
Do you want me to say something?
Sorry. Just not yet, Miss Nathan. I'm just Miss Rosas. So if either Taylor or what is her name, Ashley, if they have information that would be helpful, but those are the things that Miss Nathan has absolutely proven for the court today. The oven, the floorboards, the wall, the bathroom, the garage need to be cleaned out, the junk being removed from the backyard and from the side yard, the air ducts needing to be cleaned because that was filthy. The back door, the front door, the master bedroom door, a new fridge, weed repair and yard, and then back rent.
Okay. I know there is evidence that the home did not come with the fridge. The fridge that was there was broken. It was not a new fridge. My son,
Ms. Rosas, there's a contradiction on what you just said. It either came with a fridge and the fridge was old and broken, or it didn't have a fridge at all and they brought it a broken fridge.
Yeah, they brought the fridge in.
And so then they left one behind.
Yes. The statement of the police report where the washer and dryer were stolen.
Washer and dryer are not part of this.
Oh, okay.
She has not, she's not shown that at all. It may be true, but I didn't see a receipt for that. That's not part of what I saw, the photos, the bills that were submitted thus far.
I do know that there is emails of requests to repair appliances, the back door due to the freeze. I can certainly try.
I'm happy to give you a 10-minute reset. I'll give you a 10-minute continuance, see if you can get a hold of someone. And we'll take a look at it.
Have them email that? Yeah.
More importantly, have them come to the Zoom so I can ask them questions because that's cross-exam, right? The emails will have limited value. What I need to hear is the person who actually lived in this house say, no, that's not true, because what she just showed me is based on historical evidence. It's not her today telling me, it's what she found and documented back in May and in June, immediately following them moving out.
Correct. Okay.
Okay. Why don't we take a 10-minute recess? It's 3:20. We'll all come back at 3:30. Okay. Y'all can all take a minute
all right.
and stand up.
I'll start working on it.
Okay. Thank you. We'll be back in 10 minutes.
Thanks.
Thank you.
Back, everyone. We'll give parties a moment here to turn their cameras back on.
I wasn't.
Sorry. Go ahead.
That's fine. Miss Rosas, were you able to reach anyone?
No, I wasn't able to reach anyone.
Okay.
I tried several times and sent an email.
Okay. Well, I will just share my screen 2 more times because I did take a look in the break at the lease, and I'll highlight something in the lease, Miss Rosas. So in the original residential lease, and I'll share my screen again. On page 1, it does delineate that the property is being rented and it comes with the refrigerator, a washer, and a dryer. So those items were detailed on the original lease as being included. And then I did see that once the tenants moved out, the plaintiff filed a police report indicating that the things that were missing, and this was done May 5th of 2023, that what was missing was a washing machine and a dryer.
I understand. I wish I had Ashley here. She has an email where she purchased those washer and dryer. In 2021, go ahead.
Go ahead.
To be honest with you, I just was trying to assist my son to stay in the home he had been in. He for the
Miss
I should have read it. I should have read it, and I didn't read it when I signed it. So, I will just have to deal with it, and I will, depending on your judgment, will decide what I need to do from this avenue forward. Unfortunately.
How about you deal with your son?
Unfortunately, I don't have, in fact, I came to your precinct today. I was not aware that I had access to this evidence. Your clerk at the precinct printed all this evidence for me today. So I'm in a conference room now at a hotel. I asked permission if I could use their hotel conference to do a call. They said yes, because I wanted to stay close by to the court. So I did get the evidence. As you reviewed it with the plaintiff, I was going through there and trying to piece it together per my memory of how things occurred. So unfortunate for myself, I don't have the evidence necessary to dispute some of these issues. And I wish I did. I didn't know how to handle this. I did try to seek counsel. No attorney was willing to take this case. It's just not something they do. It's a very difficult, I've been through quite a few, a lot. I understand the evidence. I wish I had the rebuttal for these evidences. I know that one hole behind the door, that is a doorknob hole. We were in the process of cleaning and doing the repair when unfortunately the plaintiff was terribly upset, asked us to leave the property, or she was going to call the police and charge us with trespassing, even though Taylor and her agreement has always been half the rent on the 1st and half the rent on the 15th. It's always been that way with her. That was an agreement and accommodation she did so he could continue to rent there. So in May, during the cleanup, Taylor has this text in his phone, his broken phone. It just doesn't hold a battery charge, so it's always dead. Which I wish I had, so you could see where we were asked not to return, even though he had already paid the first portion of that rent, which didn't allow us to finish what we were supposed to do. And that was to properly clean and move those things. And there is an email also regarding that refrigerator and how to handle that refrigerator per Priya. I unfortunately do not have that email from her or text messages. It's unfortunate for me, but you know, your honor will have to make the decision according to your beliefs and understanding. But if we had where I could come back with the evidence, I'd be more than happy to be better prepared. I do have all the evidence. I've got this whole table full of papers, and I'd be more than happy to bring those rebuttals and the text messages and the emails corresponding with some of these damages. The rear door, was a freeze damage that I know that she was notified of, and it was never corrected. Taylor just did not have the funds to try and help do it and have it deducted from the rent per her statement. But she was advised of the appliances and so forth, that they weren't working properly and so forth. And those are the same appliances since the original lease started in 2015. Yes, 2015. But in either case, it's your decision, Your Honor, if you want to allow me to produce the rebuttal evidence for some of these evidential pictures that have been provided by the plaintiff.
I appreciate that, Ms. Rosas, and I'd say today is the court date, so we can't
Sure.
continuance now that we've already had all this testimony, but you absolutely have a right of an appeal. And I have a
Okay.
few more questions for Ms. Nathan. So
okay,
let me share my screen now, Ms. Nathan. Let me show you the other letter that was sent related to the damages, and let's just take a look at what's on that letter that I haven't seen already, okay?
Yes, Your Honor.
Okay, so here is kind of the updated letter, right? And so, in this one, we've got this unpaid rent for May of $1,200, and then this April balance of $50. And then there's late fees, $225 and $450. And then property damage. So we've covered the HVAC. You said you're not going to charge for damage to the carpet, damage to the walls, filling in holes, patching and paint job with $750. Up at the top here, damage to the floors, broken tiles. I didn't see any broken tiles, dirt and grime. I definitely can see that. Patching, filling, and deep cleaning. Damage to the baseboards. I saw some of that. Damage to the doors. I saw that. Appliances, fridges broken. Install, delivery, remove old one is $1,525. But the receipt I actually saw was for $857. The appliances, $1,675 for the washer and dryer. So, Miss Nathan, when were the washer and dryer first purchased?
So yes, Your Honor, the washer and dryer was first purchased in 2016. That's when I actually bought the house.
Okay, and in
And then-
2016, what did you pay for the washer and dryer?
That was the amount I got from that original payment that I had made in 2016. And I didn't replace it yet. I still haven't replaced the
Miss
washer.
Nathan, how much did you pay in 2016? Did you pay $1,600 for a washer and dryer?
Yes, Your Honor, correct, for both, yes.
Okay, that's what I want to know, because you don't get replacement value, you get less depreciation. But so that's what you're putting in here, but that's what you paid for them in 2016. Okay. Oven, you wanted to replace the oven. Was the oven something you purchased in 2016, or was it an oven that came with the home when you purchased the home?
I had to purchase with the house, Your Honor.
So the oven was there when you bought the house?
That's correct, Your Honor.
Okay, and do you know what year that oven is?
2016.
It was brand new in 2016.
That's correct, Your Honor.
The oven was brand new in 2016.
Yes, Your Honor. Everything was brand new.
Okay, how much did you pay for the oven when you purchased it new in 2016?
I was asked to pay close to $2,000 for everything, Your Honor. So I would have to.
Miss Nathan, how much was the oven in 2016? I'm looking at that oven. It's an electrical top oven. That oven is not a $2,000 oven.
No, I'm not saying just the.
How much was the oven?
I would say about $1,000 because it was a combined bill I got for that and the range and the duct and everything. So I'm splitting it in my head to.
Got it. So in 2016, you spent $1,000 for the oven and the range top. Okay. And the hood above it. And now you want $1,100 for it. Bathrooms, we saw the bathrooms, blinds, all the blinds were damaged and needed replacement. $925. I saw one photo of blinds. They didn't look damaged. They look off kilter. Do you have any other photos of the blinds?
There was one more, Your Honor, where the blinds were completely taken off in the guest room. It had like a green background.
Okay. All right.
But it was
$475. Garage, we saw that.
And some of this
jump removal, saw that.
Yeah.
Service disruption, you charge them $250 for turning off the utilities. And then what is this $2,080 for lost time? What's that?
That was just my time, Your Honor, like.
You don't get anything for that. I appreciate that. I understand that it's frustrating, but there's no such thing compensable under Texas law for that. Okay.
And
We
I
can
also
take that
sent,
out right
I just, on the break, I sent proof of the, for Austin City's bill for the termination of water and electric. I sent that over to the court as proof. And I know I didn't have all of the invoices. Some of them I had to pay cash to save money. So I don't know how I'm gonna, I don't know if I'll be compensated for it, but I did send the proof of city, Austin City, with the address on it.
And that's what it cost you to turn the power back on?
Yeah, they actually, I absorbed $50 as transfer fee. I didn't charge them that, but the rest of it is to turn it back on, Your Honor.
All right. So we saw receipts totaling 11,824, and then just now we went over washer and dryer. I give you 800 for those. For the oven, I'd give you 500 for that. And then you get the May rent of 1,200. So that would bring the total judgment today to the plaintiff in the amount of $14,324. And then to that, you also get your cost of court, and then that would accrue interest at the standard rate of 8.5%. So that would be a judgment for the plaintiff, $14,324. And again, I find that based on the receipts that I saw for the oven. Actually, I need to take out 500 for that. I apologize, y'all. I'm double billing for the oven. Judgment is $13,824. Okay, and that is for May's rent, $1,200, washer and dryer at $800 for their depreciated value, $1,187 for the oven and the repair of the vent, $900 for the floors, $750 for the wall, $575 for the bathroom, $1,250 for the garage cleaning and deodorizing, $300 to remove all the junk, $4,600 on the air duct, $675 on the back door, $400 for the front door, $125 for the bedroom door, $205 for the door fittings, $857 for a fridge and the weed stop. I think that seems reasonable given all things considered. And then did I say in the $1,200 for the rent? So $13,824 to the plaintiff.
Your
plus
Honor,
cost of court.
sorry to interrupt, Your Honor. What about the water and electric turn off and
I'm not going to include that, Miss Nathan. I
Okay.
think $14,000 almost against Miss Rosas. You didn't even include the original tenants. Okay, good luck to both parties. Miss Rosas, good luck to you. Both parties have a right to appeal. You have 21 days to appeal. The date, 21 days starts counting tomorrow. Okay?
Thank you. Your
Okay,
Honor.
thank
Good
you
luck to
very
everyone.
much,
Thank
Your
you
Honor.
very much. Again, no one here was at fault. That's pretty clear to me. Miss Rosas, you co-signed. Miss Nathan, you did a good job of documenting everything. Good luck to both ladies. Kids are fun.
Yeah, they are. They
All
are.
right.
Thank you so much for your time, Your Honor, and
Thanks, Your Honor.
thank you for the advice. I will be appealing.
Okay,
Have a good
thank you.
day.
Good afternoon, everyone. All parties to that matter are excused.
Well, there you go. And someone had asked earlier if we thought she would appeal, and she says she's going to. Yeah. That, oh man. $14,000 for something you didn't even do. That's why you just don't put your signature on anybody else's paperwork. These kids need to pay that mom back. You're welcome, sweetie. I'm so happy you joined tonight. Yeah, I love that judge. I really do. There were not before picks. And I think part of that is because they said that he and his friends already lived there when she purchased the property. It would be nice if I knew when it was happening, but I'm not good at tracking stuff like that unless they say the date. Yeah, maybe he was ruining her stuff too. It's possible. My guess is drugs. That would be my guess. I mean, I have no way of knowing that because, you know, he didn't show up. You know, he wasn't sued, but he doesn't have a phone. Mom doesn't have a way to contact him. The landlord had no idea where he was. That's why he wasn't included in the lawsuit. Yeah. Well, Michigan is harder on landlords than it is on tenants. This was Texas. I think it seemed a bit more fair in terms of the, you know, landlord tenant bias, but I know Michigan, you remember Judge Marable, how he was with landlords? Whoa, you did not want to be a landlord in his court. Hi, Earl. Earl's getting up on the kitty loft. Yeah, there's no way for us to know. Absolutely. I hear Billy giving us his sing-song goodnight. No. She said she would have to call his girlfriend. Absolutely. I think taking a walk through video when, you know, when you first rent a place out, both the landlord and the tenant should be doing that. Pictures, video, you know, making sure that you keep that safe because that's your proof. Yes. I know, I miss him. I miss him. He was funny. All right, guys, if you couldn't tell, I'm kind of feeling under the weather, so I've got a bit of a chest cold starting up. Crazy old lady mentioned it could possibly be the wildfires up north, so I don't know. I've taken some allergy meds, I've taken some sinus meds, and now I'm going to take some sleep. Yes, that sleep does a body good. But thank you all for coming out, and I really appreciate you guys. Be safe, be well, sleep sweet, and much love.